The Supreme Court of the United States, the highest court in the land, the court of last resort from which there is no further appeal. Its job is not to write the laws or enforce the laws, but to interpret them, to examine the Constitution of the United States and the laws of the land, and to decide what they mean.
The Constitution establishes three co-equal branches of the government. The executive branch consists of the president and everyone he employs and appoints to enforce the laws. The legislative branch is the Congress, which consists of the 535 persons Americans have elected to write the laws. The judicial branch, the least understood part of the government, consists of the approximately 1,000 federal judges and 9 Supreme Court justices. Their job is to interpret the laws the Congress has written and to hear challenges to behavior that the president has authorized. The Constitution itself only establishes the Supreme Court, but by giving that court the right to hear appeals, it implicates the existence of lower federal courts. Hence, the first Congress, in its very first piece of legislation, enacted the Judiciary Act of 1789, which set up the federal courts, much as we still find them today. That law divides the country into judicial districts based upon population and geographical distances within the states. For example, Delaware has 1 judicial district, New York has 4, and California and Texas have 5. Each state has at least 1 district, and each district has from 5 to 20 federal district judges. These are trial judges who wear black robes, work in courtrooms with or without juries, and preside over federal trials, both criminal and civil. If the feds, for example, charge someone with robbing a federally chartered bank, or failing to pay income taxes, or dealing drugs over interstate lines, that person would be tried in a federal district court in the judicial district wherein the feds contend the crime occurred. If someone else sues in federal court for libel or slander or theft of trade secrets or patent violations, that lawsuit would be tried in a federal district court in the judicial district in which the plaintiff claims he was harmed. Federal district judges are appointed by the president and confirmed by the Senate, and they have their jobs for life. The Judiciary Act also divides the country into 13 judicial circuits. Each circuit contains a few dozen districts within a half dozen or so states. Each circuit has about 15 circuit judges, and they hear appeals from decisions of district judges. So if someone is convicted, for example, of a federal crime in the district court for the District of New Jersey and wants to appeal that conviction, he would file the appeal in the United States Court of Appeals for the Third Circuit, of which New Jersey is a part. He would file that appeal in Philadelphia, which is where the judges of the Third Circuit have their courtrooms and their chambers. 3 circuit judges hear each appeal. They can affirm a conviction or jury award, reverse it, or modify it. The basis of an appeal is the contention of mistakes by juries or district court judges. Circuit judges are also appointed by the president and confirmed by the Senate, and they serve for life. The highest court in the land, the court of last resort, from which there is no appeal, is the Supreme Court of the United States. It has 9 justices who all sit and work in the Supreme Court building in Washington, across the street from the Congress and a few blocks from the White House. The Supreme Court hears appeals from the circuit courts and from the Supreme Courts of each of the 50 states. Supreme Court justices are also appointed by the president and confirmed by the Senate, and they serve for life. How does a case get before a federal judge? Can the courts just look at legislation like health care in the Congress and simply declare them unconstitutional? And if all 3 branches of the federal government are co-equal, how can the courts stop the president or invalidate acts of the Congress? The Constitution limits the authority of the federal courts to real cases and controversies. Thus, if the feds are prosecuting you under a law, you can challenge the constitutionality of that law. Or if someone sues you under a federal law, you can challenge the constitutionality of that law. If you are not personally threatened under a federal law in a manner different from the general enforcement of the law upon the general public, then you are not in a position to challenge it, and the courts are not in a position to rule upon it. The framers did not want judges interfering with lawmaking simply because they disagreed with certain laws, but only when some person would be uniquely and unconstitutionally harmed by the enforcement of the law. For 200 years, we have accepted the principle that it is the job of judges to say what the law means and what the Constitution requires, and we have given to them all the final word.
The whole purpose of an independent judiciary is to be anti-democratic, to assure that rights are upheld and the Constitution is enforced, to make sure that a popular majority cannot take liberty away from an unpopular minority. That's what inalienable rights means.